All rise. The Supreme Court of the State of Colorado is now in session. Chief Justice closed for the night.
Thank you. Please be seated. We scheduled oral argument this morning, first for 1 hour for the case of Marco v. People. I'll just do as I did yesterday and remind you all that we record these, so if you announce yourself at the podium and say who you're representing and then try to talk someplace close to the microphone, that would be helpful. If both counsel are ready, Mr. Kratz, whenever.
If I can ask the bailiff to turn the lights on in here. It's under video setting 1, or the lighting setting 1. It seems a little dark.
Good morning. May it please the court. My name is Alan Kratz, and I'm representing the appellant in this matter, Mr. Robert Marco. This court granted certiorari in 2 issues in this case. This morning, I would like to primarily address the first issue concerning the trial court's denial of the challenge for cause of Juror C, a juror who made problematic statements about the insanity defense. Now, below, the Court of Appeals did not address whether this denial was erroneous, instead concluding that no reversible error was possible under this court's decision in Novotny from 2014. In a footnote, the Court of Appeals also concluded that Novotny applies retroactively, but did not actually address Mr. Marco's arguments as to why Novotny should not apply retroactively. In Novotny itself, the majority opinion also did not address retroactivity, but did acknowledge that it was going against stare decisis by expressly overturning a bright-line rule that had been decided more than 2 decades previously. In other decisions, this court has recognized that due process principles of notice and fair warning may preclude retroactive application of a judicial decision. Most recently in La Rosa, this court declined to apply a newly minted corpus delicti rule retroactively.
Mr. Kratz, I hate to, you're working up a head of steam there. I hate to derail you, but the threshold issue, of course, is whether there was any error in the first place. And so help me understand why on these facts there was error in denying the challenge for cause based on the way it ultimately shook out. I'm struggling with that.
Your Honor, I think that the record is very strong that the challenge for cause should have been granted in this case. Juror C repeatedly made statements indicating that anyone who asserts an insanity defense gets off too easily. He also made statements basically that there would have to be overwhelming evidence of insanity before he could even consider entering a verdict of insanity. And he made particularly problematic statements that any expert testimony that the defendant was insane at the time of the commission of the offenses, that he would basically reject that out of hand unless the mental health professional was there. That's how he put it, unless he was there, which of course is not going to be the case.
But all of those statements, Mr. Kratz, good morning. All those statements were made before the court instructed at the law, and then the juror said that instruction was really helpful. Thank you. And now I understand better. I can follow the law. I mean, I don't think he made any of these concerning statements after the fact. How does that play into your analysis?
Well, I think the problem there, Your Honor, is that the court merely instructed the jury on the principle that the prosecution bears the burden of proof with respect to the insanity defense. But unfortunately, the court's statements were very confusing, I'll put it that way. Many times the court seemed to indicate that the defense had to present strong evidence of insanity and therefore the jurors should not have a problem with the insanity defense because the defense had to present strong evidence of insanity. Also, the court, while it got Juror C to give a one-word answer, yes, as to whether he could enter a verdict of not guilty by reason of insanity and whether he could obey the court's instruction as to the burden of proof, but the court never questioned him about his other problematic statements, specifically his statements that there would have to be overwhelming evidence of insanity, which makes it sound like, okay, I'll hold the prosecution to the burden of proof, but that burden is going to be very, very small, in my mind, speaking as Juror C here, because I think there has to be overwhelming evidence of insanity, and I'm not going to pay any attention to their expert unless he was there, he or she was there. So,
Did counsel below, and I just don't remember, raise any objection to the instruction the court gave?
in my recollection, there was no objection, unfortunately, which is unfortunate because I think the court's statements were all over the place there.
And didn't defense counsel actually follow up on the second day after the instructions with that particular perspective or that particular juror and ask whether there was anything from the day before that had been talked about that was an issue, and then the juror said that he could follow the law and that once the instructions had been given that he understood now how things worked and he was going to be able to follow those instructions?
Well, Your Honor, I think you might be paraphrasing his statements a little bit, but I think, yes, it's true that the court the next day asked him whether he could follow the court's instructions, whether the court's explanation, which, as I've said previously, was not particularly accurate in terms of the insanity defense, whether now that he had heard those new instructions, whether he could follow the law. And he said yes.
But my recollection is defense counsel asked him about that too, right, about following the law and the burden of proof, and the juror gave appropriate answers to both questions. Am I misremembering that?
I don't recall that occurring.
Can I
It's
ju-
possible
can I
it
jump
occurred,
in?
but
Let me jump in. He said, defense counsel said, after questioning, said, so you're fine following the law, you're fine keeping the burden on the table? And the juror said, absolutely.
right. That's also what the court asked him, and he also gave those responses.
Well, how do we find an abuse of discretion if a juror says, absolutely, I'll follow the law?
Well, again, Your Honor, I think it's because the court never inquired of the juror about several of his problematic statements in terms of how he would hold the prosecution to its burden of proof. While he definitely said, okay, fine, I understand that the prosecution has the burden of proof, the court never questioned him or rehabilitated him with his problematic statements concerning how he would apply that burden of proof, specifically that he would require overwhelming evidence of insanity, and also his problematic statements that any expert who testified on behalf of the defense that the defendant was insane at the time of the commission of the offense, that he would discredit that testimony unless that person was there when it happened. So those were the statements, in my opinion, that were not rehabilitated, that his one-word answer, yes, I can follow the law, did not address.
Well, counsel, I'm not sure it's fair to characterize his entire answer as just embodied in that one word. He said that, but then he also said the statements that have been mentioned here. He said in response to defense counsel, it's one of those situations that we really do have to set aside our personal feelings. I mean, it seemed like, and he said he had taken the night to sleep on it and the definitions helped. So I think the trial court hearing that, it was after that the trial court said he would make specific findings on him, and said that today he even came in and clarified that once he had heard the instructions on what insanity was, that he was more open-minded or more receptive to the concept of not guilty by reason of insanity. Given all of the colloquy about that, that's more than just yes.
Yeah, and Your Honor, I was thinking of a specific moment when the court asked him, can you follow the burden, can you apply the burden of proof on the prosecution? I'm paraphrasing there. And
Yeah.
he said yes. I'm not denying that he made other statements, but I'm still asserting that the problem is, first, the Court of Appeals instructions on the insanity defense were not very clear. And more importantly, Juror C made statements indicating that while he would be able to apply the burden of proof and place it on the prosecution, that he didn't understand what that really meant. That for him it meant, okay, that I'm going to presume that burden is met unless there's overwhelming evidence of insanity. And I'm not going to credit the testimony of an expert who says someone was insane at the time of the commission of the offense unless they were there. It was those kinds of statements that were really problematic in my opinion. And it's also interesting that he made such an about face too. At the first day, he repeatedly made statements saying that people who assert an insanity defense get off too easily. And then the next day, yeah, okay, fine, you instructed me on insanity, I can follow the law. Still very problematic in my view.
So if I derailed you initially, I'll put you back on track now. If we reach retroactivity, what should we do?
Yes.
Yeah.
Yeah, and as I was saying, in Novotny, the majority opinion did not expressly address the issue of retroactivity, but did acknowledge it was going against stare decisis. And this court has in other cases applied due process principles to the decision as to whether a judicial decision should be applied retroactively. In La Rosa, this court's reasoning was essentially twofold. First, in La Rosa, this court declined to apply its rule retroactively because the overturned rule was still followed in many jurisdictions, some of which had in fact rejected the reasoning on which La Rosa found to be persuasive. And second, the prior rule had been followed in Colorado courts for many years. Well, if we look at the McCrander rule, the same rationale applies. It was followed, it cannot be denied that it was followed in this court for many years. And it also is true that many jurisdictions continue to apply the McCrander rule and have rejected the arguments which Novotny relies upon to overturn the McCrander rule.
Could I ask you a question about what we did decide in Novotny?
Sure.
Maybe one way to approach that is La Rosa. Given the fact that we said it would be a due process violation, did we apply it, the new rule, to the defendant who was at issue in La Rosa?
I believe in La Rosa, the court, I'm not certain if the rule was applied to the defendant in La Rosa. The court definitely held that it should not be applied retroactively.
Maybe a way to turn that around is, did we apply the new rule to Novotny?
Yes, it does appear that the new rule was applied in Novotny, or at least this court remanded for application of the outcome determinative test without any greater specificity.
Is that consistent, you think, with not applying it retroactively?
Well, I think the problem there is that there's nothing in Novotny indicating that retroactivity was raised as an issue. And so ordinarily, of course, a court, when it issues a decision, makes a holding, is going to apply it to the parties in that case. And when there's nothing in the decision indicating that retroactivity was addressed, I don't think we can infer from that this court had made a decision that the rule in Novotny should apply retroactively.
Perhaps I can ask one follow-up too. Do you think it's significant at all that in its stare decisis portion of the opinion in Novotny, the rationale for changing the rule was expressed largely in terms of the rule having already been changed by prior case law and it being important for us to recognize the change so lower courts would no longer be bound by McCrander?
Well, Your Honor, this court, if I recall Novotny correctly, this court had a lot of discussion about the structural error, trial error dichotomy, and how under this court's decisions, it had reached a point where it was like, well, something's either structural error or it's not. And What's interesting, though, is that the McCrander rule of automatic reversal was uniformly applied long after this court had started deciding cases based on structural error, trial error dichotomy. So I don't necessarily agree that decisions prior to Novotny made it reasonably foreseeable that Novotny would change the rule, would overturn McCrander and make what once had established prejudice now something that would basically eliminate the possibility of prejudice.
Since you, let me go back on what I said and ask you one more question, since you used the word foreseeable there. Do you think the due process doctrine that we talked about in La Rosa, this sort of having to do with retroactivity, do you think that because it has to do with foreseeability, do you think it has any application with regard to a rule that has nothing to do with the defendant's behavior and he wouldn't have or couldn't have behaved differently anyway?
Well, I think you know the answer to that. Yes, I do believe that it still has application to this kind of rule. And that's because the due process principles on which this retroactivity doctrine is based really concern principles of fair warning and notice. And when we have a rule like this that really reverses course on what trial counsel has to do to establish prejudice below, to me, it's very clear that there are settled expectations that are being overturned and that due process principles should apply here.
Settled expectations with regard to the defendant's behavior in the sense that some of the stare decisis cases, I think, from the U.S. Supreme Court talk about a rule that people would order their behavior according to. Is there anything in this kind of rule that would involve a defendant's ordering his behavior according to that?
Well, it really involves a rule concerning how the defense counsel orders his behavior in order to give defendant the right to a fair trial by an impartial jury. And so, in my opinion, yes, due process principles definitely should apply to this kind of situation.
Mr. Kratz, can I follow up? Had defense counsel known that this rule was going to apply, what would he have done differently? I mean, he objected to the juror, challenged for cause, and I think based on the statements that you've raised, which are concerning, it was an excellent use of a peremptory challenge. What would have happened differently?
I think that's the question, and that's why perhaps a remand is appropriate to the trial court. Now,
And perhaps you could explain what prejudice you would seek to establish on remand. What purpose would that serve, and what sort of prejudice would you hope to show there?
Yeah, and perhaps this court's opinion will help decide how you show prejudice beyond the Court of Appeals rule, which is the only time there's prejudice is if a biased or incompetent juror sits on the jury. And so it really puts defense counsel in a quandary, the Novotny rule, if that's the rule that we apply, because defense counsel is left with, if he wants to show prejudice for a court's erroneous denial of a challenge for cause, then he has to make this decision to leave the biased juror on the jury, which, of course, perhaps in some cases he may elect to do that when he thinks there's other jurors who are even more objectionable. But that's the question. We don't know what defense counsel would have done had he been aware that exhausting his allotment of peremptory challenges and using one to remove juror C would no longer constitute prejudice on appeal.
So the remand here, potentially you would want defense counsel to be able to make a record. I struck this person because of this, but I would have struck this other person if I didn't have to use that peremptory, and that's how you'd show prejudice? That's what you're talking about?
That's one possibility, yes. Now, there is an approach that many courts have taken in other jurisdictions, which have said, yes, one way to show prejudice is to show that a biased juror is sat on the jury. But another way to show prejudice is for defense counsel to exhaust peremptories and then perhaps request another peremptory saying, I've identified another objectionable juror on the jury, and I'm requesting another peremptory challenge in order to remove that jury because now I'm down one peremptory challenge due to what I allege to be your erroneous denial of the challenge for cause. Some courts in other jurisdictions have held when defense counsel does that, prejudice may also be established. So, this court, of course, hasn't decided that question.
Mr. Kratz, your time is fairly limited, of course, and want to make sure you address the custody issue before you sit down and save time for rebuttal. Could you turn to that?
Sure.
Before you do that, can I just ask, is there any suggestion in this case that was an additional peremptory challenge asked for in this case?
No, and I think that's probably because McCrander was the controlling precedent at that time. There was no need to request an additional peremptory to establish prejudice.
Okay.
All that was required was exhaustion and removal of the jury with one of the peremptories.
Well, that might be true to challenge the juror C problem, but if there was another juror that defense counsel thought was problematic, presumably counsel would at that point have wanted to try to keep that juror off. So it's not only for this sort of McCrander
Yeah, I see what you're
strategy.
saying.
So was there another peremptory challenge sought?
Not that I recall.
Okay.
I'm not certain though, so I would have to look at the record. I'd be happy to file something if necessary.
That's all right. Thanks.
Sure. So turning to the second issue on which this court granted certiorari concerning whether Mr. Marco was in custody once he was interrogated by the El Paso sheriff's officers at the military police, the PMO, it's called, the Provost Marshal's office on base. And the way the issue is framed by this court is whether a soldier who's under an order to accompany MPs to a military police station for interrogation by civilian police officers is in custody. But of course, the real question is always whether, under the totality of the circumstances in this case, was he subjected to custodial interrogation. So it may not be necessary for this course to answer that second issue directly. Well, let's look at what were the totality of the circumstances at the time he was interrogated. He was brought to the PMO in handcuffs. They made it clear, I'm talking about the military police officers here, they made it clear that he better not try to run. They placed him in a locked military police vehicle. They did not give him the option of transporting himself. And what's really critical here is that previously they had already come to speak with Mr. Marco. They had searched his barracks room. He had denied knowing JL at that point, and they basically told him they didn't believe him. They thought he was lying. They also, during that initial search of his barracks room, learned that he was violating regulations by having an underage female there. He was taken to a secured facility, and only after he had been brought into that secured facility by the way, he was searched again at the secured facility, and then the handcuffs were removed just prior to his interrogation by the El Paso sheriff's officers. I think it's also important to note that he was subject to military discipline, including court-martial, for disobeying the military police officers who were performing their lawful function.
But only to go to the place, right? Not necessarily to submit to interrogation. And he was told he was free to leave by McCormick at the time that the interrogation began, right? So
That's true.
Help us with that. That's the tough fact for you. So
Right, and
Yeah, if I can add a couple of facts which are my concern. He was told he was not under arrest, he was free to leave, and when he was done, he was allowed to leave.
well, I disagree with that last part, Your Honor. He was kept in the PMO for well over 24 hours. In fact, kept in that same room for most of that time, if not all of that time. So I don't agree with that. And yes, obviously the police officers did say he was free to leave, but the problem is this is from the civilian police officers, and he had no indication that he was free to leave for purposes of the military. He had been ordered to go there to submit to interrogation.
But the military personnel left, right?
The military personnel were still there they were not in the room, but they were still present, of course, in the PMO.
But they were not in the interview room.
Not initially. Later on, I believe there were some military officers or personnel who were present. But at the initial interrogation, the unwarned interrogation, they were not present in the room, yes.
So free to leave, then the statement by the civilian police officers was essentially negated by the fact that he'd been ordered to be present at the provost marshal's office. Is that your contention?
My contention is that's one fact to consider, and there are other facts as well. You know, in cases like Efland, Minjarez, this court has noted that just being told you're free to leave is not necessarily going to make the situation non-custodial when all other circumstances are to the contrary. And here we have lots of other circumstances to the contrary, as I've already gone over. They basically believed he was lying. They believed he was responsible for her disappearance at the outset.
In terms of the restriction of movement, though, any such restriction was imposed by the military, not law enforcement. And so I guess I'm struggling with that piece of it. I mean, from the police's perspective, he was free to leave. And so his inability to do so had nothing to do with action taken by law enforcement. So help me understand how that then plays in.
Your Honor, I think that what we have to do is look at the actual test. It's whether a reasonable person in his situation, reasonable soldier in his situation, would believe his movement is restricted to the degree associated with a formal arrest. And if you look at the circumstances, they all indicate to a reasonable person that the civilian police and the military police were acting in concert.
Didn't he ask and wasn't he told by the military police that he was not, in fact, under arrest, at least from the military's perspective? The handcuffs was just part of the protocol. They were removed as soon as he arrived. Am I misremembering the record on that?
The MPs may have made a statement that you're not under formal arrest, but they also told him, you better not run, you have to come to the PMO, you don't have the option of transporting yourself, he has to get into this secured vehicle. So just because he's told he's not under formal arrest doesn't, in my opinion, is not dispositive. The real dispositive circumstances are all the other circumstances to the contrary, which indicate that he's not free to leave. He has to go to this PMO and be interrogated.
So the continued use of that phrase also brings to mind the way in which we have repeatedly said that counsel should be mindful not to conflate the Fourth Amendment seizure standard with the Fifth Amendment custody standard. And so that difference seems very much at issue here as well. Talk to me about that, why you think that this goes beyond seizure and is commensurate with formal arrest.
Well, yeah, that is an interesting question because the trial court below at times seemed to conflate the two principles. At times the court was talking about a Fourth Amendment seizure, and really the question under the Fifth Amendment is the Miranda test, whether a reasonable person, in my opinion, a reasonable soldier here, would believe that he's not free to leave to the degree associated with a formal arrest. And this court has talked a lot about the kinds of circumstances that exist here which make the situation custodial. You've got armed police officers ordering someone to go to the police station. He has no option to go later. He's put in a locked police vehicle in handcuffs and transported to the military police station where he's searched several times. Police have already questioned him at the scene of the barracks and basically told him they think he's lying about not knowing JL. So at this point, any reasonable soldier, I think, in his position would believe that he has to submit to this, and he has to undergo custodial interrogation.
You mentioned a few minutes ago that he was court-martialed for not following orders.
No, I didn't say he was court-martialed,
Oh, I
Your
thought
Honor.
you did. Okay. But that he was disciplined somehow by the military for not following
My
orders.
point was that he would be subject to discipline for disobeying.
Okay.
Yes.
And the order that he received from the military police was to go to the military police office.
Yes, to be interrogated by the civilian police officer.
Was he ordered to answer their questions from the civilian police?
I don't recall any specific statement in the record where they said we ordered him to answer the questions by the police. But again, I think all the circumstances indicate that the civilian police officers here, McCormick and Shannon, were working together with the military. And so a reasonable person in Mr. Marco's position would believe that, yes, he's under orders to submit to this interrogation.
Mr. Kratz, why do you say that the reasonable person would think he was the military working with the civilian officers? I'm forgetting now the name of the case that you were relying on, Rogers, I think it was, where there really was clear evidence that the military understood they were setting this guy up for an interrogation, et cetera. Here, the military was at, the police, civilians said, bring him here, and they did. I mean, they weren't in the room, they weren't involved in the interrogation. So what's so clear that they were working together?
Well, several factors, I think. First, the military police were the ones who come and first question him about the disappearance, and they're the ones who tell him not to run, that they're going to transport him to the military police office. He's not transported to the El Paso Sheriff's Office at this point. So all these circumstances indicate that, oh yeah, he's being questioned by civilian police authorities, but they are working in concert with the military in this situation, in my opinion.
Thank you.
I think we've
Looks
managed
like
to
I ran
use
out of
up all
time.
your time. Thanks.
Thank you. Just ask this court to reverse the judgment of conviction. Thank you.
Good morning. May it please the court. My name is Rebecca Adams. My registration number is 31044, and I represent the people in this matter. I'd like to pick up where the defendant left off and address the custody issue. While this case presents a unique set of factual circumstances that this court has not been previously called upon to address in the context of custody determinations, the standard remains the same. The question is whether, under the totality of the circumstances, a reasonable person in the defendant's position would consider himself deprived of his freedom of action to the degree associated with a formal arrest. In this case, the answer is no. Now, of course, the court is aware of the factors that it may consider. There's no single factor that is determinative, and this court is not limited in the number of factors that it may consider. While the defendant was originally picked up by the MPs and taken to the PMO, and he was handcuffed during this time, all of this was action that was taken on the part of the military. It was not at the request of the civilian police. It appears that the civilian police were not even aware that this was occurring, and the military police did advise the defendant that he was not under arrest. When he asked, they told him that while they were handcuffing him, this was only for safety and transport purposes. Immediately upon arrival at the PMO, those restraints were removed. The MPs took the defendant to the interview room, left him with the civilian police officers, and they had no continued contact with the defendant throughout the remainder of this initial interview period. And there was absolutely no restraint placed upon the defendant during that initial interview.
Go ahead.
I was going to say, even though he was told he was free to leave, though, where was he going to go? I mean, he's 2 miles away from his barracks. He's got military police standing outside. If he were to leave, wouldn't they just send him right back in?
I don't think that there's any evidence in the record to support that. The trial court's findings were that the defendant was free to leave, and there's nothing to indicate that had the defendant asked to leave, that the civilian police officers would not have honored his request. While the MPs were still in the building, this was a military police station, but they were not stationed outside his door. It's not a situation like it was in Efland where they were sitting outside and the defendant was aware that they were there. They were simply going about their business. They had no contact with the defendant. They weren't guarding the door. There was nothing to indicate that he was required to stay. He certainly could have told the officers that he wanted to leave, and he could have returned to his barracks.
And
Well, I'm sorry, go ahead.
just, one more question.
All right.
Yes.
And what do we make of the fact that he was held there on 72 hours in the military police office?
Well, and again, all of that occurred after the defendant had received his Miranda warning. So whether or not he initially felt that he was in custody during that pre-Miranda period, whether or not he was subsequently placed on this hold has no bearing on his the reasonable person at the time of this initial interview.
But for the free to leave comment, do you think he was in custody?
No, I do not, Your Honor.
Okay, help me with that.
I think that, again, we have to look at all of the factors that we have here. I think it's also relevant that the purpose of this encounter was not because the police suspected the defendant of any wrongdoing. They didn't accuse him of anything other than not being truthful as far as knowing the missing person. But at the time of the initial interview, all they were doing was investigating a missing person. They were trying to find where she was. They had no indication that he was involved in her disappearance or had harmed her in any way.
That sounds like the old focus of suspicion test. We've long since gotten rid of that, right? So does that really matter?
I think that it does. In many of the cases, we talk about whether or not the officers were accusing the defendant of some contact, whether or not they were asking open-ended questions or they were providing him with the information that they have of his guilt and asking him to just answer yes or no and agree with them. In this particular case, they had no information. It was a very open-ended conversation. The tone of the interview was conversational throughout. So while they did, in fact, provide him with some information that he had contacted this woman, there was no information that anything had happened, that any crime had been committed here.
But you're focusing on the circumstances in the interview room. I guess it's hard for me to ignore the events that preceded that, even with the MPs telling him he wasn't under formal arrest. It's certainly all of the events preceding him walking into that interview room had the hallmarks of traditional custody, right?
I do think that we certainly can look at the incidents that lead up to the interview. But I think the crucial inquiry is the level of restraint at the time of questioning. And so, and again, just because he may have been seized prior to this interview, a seizure does not equal custody. So whether or not he was even temporarily seized by the MPs when he was brought to the interview room, that seizure ended at the moment that he arrived at the PMO.
But what if it was temporarily arrested, right? If he was subjected to formal arrest, can it then no longer be formal arrest in the interview room by the same logic?
Well, I don't think there's any evidence to show that he was formally arrested at any point prior to this. Certainly at the time, and again, we don't have a situation where the military police and the civilian police were working in concert.
But how would he have known that? I mean, I think if what we're supposed to be looking at is from his perspective, and I have actually sort of two questions. I know that it's a reasonable person, but it seems as if Mr. Marco had some mental disability. Do we take that into account with someone who has PTSD and I guess I don't know all the other problems that he has, but he does seem to have some disability. In that situation, having been had his room searched, been handcuffed, been brought to the military police office where these civilian police are waiting to question him, wouldn't a reasonable person, particularly with his disability, look at all of this and think, well, why would a reasonable person draw a distinction between what the military police were doing and the civilian police were doing? It's all one event from his perspective, even if it's not from the police perspective.
Well, I'm not sure that that's entirely true. And I think that in looking at all of the actions that led up to this interview, when we say that the MP searched his room, that's not entirely accurate. What they did was a quick look through his room to see if the missing person was in his room. They were not going through his drawers. They were not going through his things. It was a very cursory look, they did in fact find a 17-year-old girl in his room at that time. But even after that, he was allowed to leave the base to drive her home. So there wasn't this idea that he was somehow being restricted in some way by the military even at that point. And again, I'm not sure, as far as the custody determination goes, this is someone who is on a military base. He is probably aware that civilians are not just allowed to go to the barracks to question him. So it probably doesn't seem unreasonable at all that he would be asked to go with the MPs to the PMO to talk to these civilian officers.
But would it be typical to take him in handcuffs? I mean, you make persuasive arguments about the facts, and I understand it. But picking up where Justice Hart was, I mean, we have to look at what an objectively reasonable person in his position would think. And so here's a guy taken in handcuffs. I mean, I recognize that's a protocol of some sort, but if you're him, I'm taken in handcuffs, I'm brought to the military police office, I'm kept in a room all this time while I'm being questioned. And yes, it was conversational, but it was also, this is not true. You got text. There was some confrontation there. Why doesn't that, for an objective, really reasonable person in his position with his, mental capacity, why wouldn't he think he was in custody?
I think because they specifically told him that this was in fact protocol and that the only reason he was being handcuffed was for safety and transport purposes. That's specifically what he was told. And all of the circumstances suggested that that was in fact true because as soon as the transport was over, the handcuffs were removed.
Can you help me? What exactly was the protocol? When would they put someone in handcuffs? If anytime they're going to be...
Anytime they're being transported in the police vehicle is what the MPs testified to.
Thank you.
Wouldn't it be reasonable for someone to infer from the circumstances that if he's being required to go to the PMO, that he'd have to answer questions, that he'd have to speak, that that's what was expected by his superiors in the military?
No, I don't believe so, Your Honor. He was not under any order to speak. The trial court, in this case specifically, found that he was not under any order to speak or to answer their specific questions. He was required to appear. That was it. And as soon as he showed up, the civilian police officer specifically told him that he was, in fact, free to leave.
While we're on this point, counsel, would you address Rogers for us? How do you distinguish that case?
Well, I think there are multiple ways to distinguish Rogers. In that particular case, and again, I do think that it matters, it certainly did in that case that he was advised that he was not advised that he was free to leave in that particular case. I also think that it makes a big difference that in Rogers, the military was aware that the civilian police were serving a search warrant on the defendant's home looking for child pornography and ordered the defendant to appear purposefully into the company of police. There were also a naval investigator was there at the time. And so the defendant was aware when he showed up that they were searching his house for child pornography. He wasn't advised he was free to leave. Military personnel were also on the scene. And again, he made basic incriminating statements as part of that initial interview on the scene and then additional statements.
When you say on the scene, and I'm just not remembering, was there a naval officer in the interrogation room?
Yeah, in Rogers, there were two separate interviews. One was at his house, and then he accompanied them to the police station. The naval investigator was at both places. I don't believe that the investigator asked any questions at the scene, although she was present, but she did participate at the subsequent questioning at the police station.
Thank you.
I don't want to throw you off too much because you all haven't exactly gone here, but let me just ask you if you've thought whether the sort of Garrity line of cases, Lefkowitz, Sweet Turley, those kind of things that say it would make a statement involuntary if you did it under threat of losing your job or being disciplined. You probably see this most. We've seen it with regard to internal affairs investigations by the police. Do you think they have any applicability here if, in effect, he was being ordered he perceived that as an order by the military, that he would be subject to discipline, that his job or other kinds of discipline would be at stake if he did not go and cooperate?
Well, again, I don't believe that there's any evidence in the record to support that he believed he was under some threat to cooperate, or that he would somehow lose his job or be disciplined in some way. But I will say that the defendant, in fact, didn't cooperate. He didn't provide information. So to the extent that he thought that was required, he certainly didn't comply. The defendant, during this initial interview, didn't make any incriminating statements or admit to any criminal wrongdoing during this initial period. So he certainly wasn't feeling compelled to speak.
But just to follow up on the Garrity point, there was nothing in the record that said to him essentially talk or lose your job.
No, nothing.
Okay.
And I'm sorry, I'm not remembering, did the civilian police see him in handcuffs with the military police?
The testimony was a little unclear as to exactly when the handcuffs were removed, and the trial court's ultimate findings were that they were immediately removed upon arrival at the PMO, but it was not entirely clear who observed that and exactly at what point that was done. If the court has no further questions about custody, I would just like to talk briefly about the defendant's post-Miranda statements. This initial interview, as I just mentioned, the defendant didn't make any incriminating statements. While he certainly did change his story multiple times throughout this pre-Miranda period, he didn't admit to any criminal wrongdoing. At one point, after he had changed his statements multiple times as far as his contact with the missing person, the officers decided to go ahead and give him his Miranda warnings. And then the defendant was subsequently interviewed again by multiple police officers over the course of the next several days. Under this court's recent opinion in Verrigan, which analyzed Siebert, the initial question is whether the police deliberately used this two-step interrogation procedure to obtain a confession. And of course, the people have to prove by a preponderance of the evidence that the police did not use such a two-part or two-step interrogation procedure. If the people are successful in doing so, then of course, this court just analyzes the defendant's remaining statements for whether or not they were voluntary. So I would merely point out that here there was no evidence that this was somehow part of a two-step interrogation procedure where the police were attempting to circumvent Miranda to obtain a confession and then provide the defendant with his Miranda warnings and get those same statements repeated. As I mentioned, he didn't even make any incriminating statements prior to being advised of his Miranda rights. So there's really just nothing to indicate that the police engaged in any attempt to circumvent Miranda in this case, as I mentioned.
Let me just make this more explicit. I hear you to say that even if you were to lose on custody but you went on Siebert, then it doesn't really alter the landscape here at all.
Correct.
Okay.
All of the defendant's subsequent statements, and it actually wasn't until his statements on the 13th where he actually confessed to what he had done with the victim and where he had put her body, which was 2 days after this initial.
Can we shift to the jury question?
Yes, yes, Your Honor. As this court pointed out, the initial question, of course, is whether or not the trial court properly denied the challenge for cause. I know this court has been over the record in this case. I think that the record is clear that the trial court did not abuse its discretion in this case in denying the challenge for cause. While the prospective juror may have made some initial statements once he was advised regarding the court's instructions regarding insanity, the definition of those terms, he made it very clear that he understood that he could apply the law and follow the burden of proof. And the trial court denied the challenge for cause on that basis. So I don't think there's anything in the record that indicates that the trial court abused its discretion in denying the challenge for cause.
But the argument here is that the instructions, at least some of them from the trial court judge, were wrong.
That argument was not made in the trial court. There was no objection during jury selection that the instructions provided by the trial court were incorrect. The parties discussed that there were many jurors who appeared and had trouble with the concept of not guilty by reason of insanity. The court explained that typically it doesn't provide jury instructions so early in the process because they're not finalized, but the parties agreed that it would be helpful to the jurors to explain this concept because what they know about this concept from television is not entirely accurate based on the law that we have. So the court went ahead and gave these instructions. There was at no point an objection from the defendant that these instructions were, in fact, incorrect or misled the jury in some way.
It is true, isn't it, that Juror C repeatedly said there would have to be overwhelming evidence of insanity. And I have to say, actually, reading the transcript, I had the impression that Juror C was trying really hard to get kicked off the jury, that he was not interested in serving as a juror, because not only did he talk about how hard it would be for him to believe that someone was insane, but he talked about his 3 daughters and sexual assault and how it would be pretty hard for him to feel okay about someone who had committed a sexual assault. He was not going to be a juror who was going to be open to the defendant's arguments. And so I guess although there's language in there suggesting that he sorted himself out, there's also a lot there that suggested he was not going to be able to be fair.
And I don't have the same reading of the jurors' comments in this case. I mean, he started off by saying to the court, and this was back in chambers when they spoke with him privately, that he didn't have a problem serving on the jury. He wasn't worried about his paycheck. He had a big corporation behind him. He wants to do his civic duty. So I do not think that this was a juror who was simply trying to get out of jury service. I think he was trying to be forthcoming with the court and express the concerns that he had, both that he was afraid that a plea of not guilty by reason of insanity would allow someone to basically get off. He talked about the fact that he had previously worked as a nurse and had some contact with sexual assault victims. These are things that we want jurors to express. It doesn't necessarily mean that he was not going to be a fair juror. Multiple times he said that he would look at the facts, that the facts would control, and ultimately he said that he would put aside any of his personal beliefs and focus on the law and apply the proper rules and burden of proof in this case.
I recognize, counsel, that in your view, we don't even have to get to the prejudice issue. Obviously, this is an issue, a concern I have. How would it, if we get to prejudice, how does a defendant prove prejudice under Novotny?
Well, I think in most cases, for a defendant to show prejudice under Novotny, he is going to have to show that a biased or impartial juror sat on the jury.
Is that the only rule?
I don't
Take
think
the
that
hypothetical I've expressed in writing here before. The defendant makes 6 challenges for cause. They're all erroneously denied, uses every peremptory challenge he has. Is that not prejudice?
Not if the remaining jurors that serve on the jury are not biased or incompetent.
So tell me why that's fair. Why? So the government gets, and I recognize in Novotny we said it, there's no constitutional right to peremptories, et cetera. But the defendant gets, the prosecution has 6 peremptory challenges to use, and the defendant effectively had 0. Why is that not prejudicial?
Well, I think first because what we're concerned about is making sure that a defendant receives a trial by a fair and impartial jury. If that's what he receives, then he's received everything that he's entitled to. Now, I think that some of the cases have talked about a situation where you might have a lack of good faith on the part of the trial court in denying multiple challenges for cause. In a case like that, you might be able to show harm under those circumstances, even if the defendant isn't arguing that a biased or incompetent juror sat. If you can show that the court was repeatedly and deliberately denying multiple challenges for cause to force the defendant to use his peremptories. So in a case like that, you might be able to show harm. But otherwise, what we're really concerned with here is that the defendant received a trial by a fair and impartial jury.
What about if the defendant says, in this case, left that juror on? Because there's a record of that. I intentionally left him on to create an appellate record of bias. I can imagine for the Attorney General would argue invited error in that case. They seem to be in a no-win. It's a very difficult issue, and I've struggled with it. So Are there any circumstances, Mr. Kratz talked about the hearing that he would like on remand. I'm gathering from your view that none of that's relevant. I mean, I guess that's the question. Is it relevant that for a defense counsel to get up and say, well, I left this person on, but I would have struck that one, and I thought this guy was biased?
Well, if the defendant left someone on the jury that they felt was biased or incompetent and didn't challenge that particular juror for cause, it's hard to believe on remand now that they had a problem with this juror that they never mentioned previously.
Well, let's say they did challenge the juror, but left that juror on because they thought another juror was worst, so they exercised a peremptory somewhere else.
Was the other juror challenged for cause?
Let's assume both were.
Well, I think that the defendant has to use his peremptories to remove a juror that he finds objectionable. I think it would be ineffective assistance of counsel for a defense attorney to decide to leave a juror that he finds that he believes is biased and incompetent on the jury, risking his client's conviction on the hopes that maybe he might have a favorable opinion on appeal.
And I'm just pushing you because I'm trying to figure out myself what the line would be. So would it be an example of prejudice if the defendant had to use all 6 peremptories on people he challenged for cause, and just ran out, and so had to leave somebody that he challenged for cause and lost? Would that be prejudice then?
Yes, because then you would have a biased or incompetent juror who remained on the panel and served on the defendant's jury.
All right, I appreciate your patience. Thank you.
Counsel, could I get you to address the retroactivity issue, because your briefing just sort of skipped right past that and assumed that Novotny does in fact apply retroactively?
Well, I believe that Novotny does apply retroactively. Novotny itself remanded the case to the Court of Appeals to apply the outcome determinative analysis. So Novotny applied that rule to Novotny, which at least implicitly finds that Novotny should apply retroactively. I also think that there's a difference between a case like Novotny, where the change is in a remedy for an error, versus a case like La Rosa, where you're changing the evidence that needs to be shown for a defendant to be convicted of a crime. I mean, the change in the rule in Novotny really just addresses the remedy. It doesn't change the process for challenging jurors for cause. It doesn't affect the use of peremptory challenges. There's nothing about that rule that would have changed the way that the defendant behaved at the time of trial had he known about this rule.
And I suppose to your earlier point, the fact that we chose not to apply our new rule in La Rosa to La Rosa is a distinguishing factor.
Yes.
Okay.
Does the court have any further questions? If not, we would ask that this court affirm.
Court would like to thank both counsel for your arguments. The case will stand submitted, and we'll move right on to our next oral argument, which is a 30-minute argument scheduled in the case of People versus Lozano-Ruiz. Give counsel a moment to take their place and get ready. Both counsel ready? Okay, let's get started here. In case you didn't hear me, I've been reminding everyone when you get up to the mic, if you could announce yourself and tell who you represent and talk close to the microphone. Otherwise, counsel, petitioner, whenever you're ready.
May it please the court. My name is Tanya Karimi. I'm a deputy district attorney with the 4th Judicial District, bar number 41693, on behalf of the people for the petitioner. Plain error is an error that undermines the fundamental fairness of a trial. When a trial court fails to give an instruction on an elemental definition, that is error. It is not, however, plain error when that element or issue is not contested. For an instruction to be plain error, it must be shown that 1, the error affected a substantial right, and 2, that the error, that there was a reasonable possibility that the error contributed to the conviction. When an issue is not contested, it does not affect the substantial right of a defendant's right to a fair trial, and it does not contribute to the conviction. An error is uncontested when the prosecution puts forth evidence and the defense does not rebut that evidence. That happens, for example, when a defense theory challenges one of the elements of the offense, but not all the elements. For example, in a theft case, the defense challenges the mental state, that the defendant didn't intend to permanently deprive the victim, but no jury instruction is given on value, but the defense doesn't challenge value. That's an uncontested issue. That is not plain error. Similarly, if you have a burglary where the underlying theft conviction or theft offense, that instruction isn't given, but at trial, the defense challenges the identity, but does not challenge the underlying crime of theft.
What if the defendant says, I'm innocent, they've proven none of the elements, period?
What it comes down to for a contested issue is yes, the defendant could do that. And then I guess the easiest way to address that is what is a contested issue?
That's why I asked.
A contested issue is when a defendant points to evidence in the record that an element does or doesn't exist, or that a defense exists. The best example of that we have from this court in the Almond case, where intent was contested by both the prosecution and the defense. It was also a burglary case or burglary instruction where the intent element of theft was not given to the jury. However, the prosecution argued that the defendant, when she entered and trespassed, that she had the intent to steal the victim's items. The defendant argued at trial that no, she was there to retrieve her own items. So that was an issue placed squarely in front of the jury, and not having that jury instruction regarding intent, that created a reasonable possibility that had the jury had that instruction, that there could have been an acquittal. So that is an example of a contested issue.
But would you be saying then that simply standing on a general denial, exercising your right to remain silent and force the prosecution to prove its case, would be a failure to contest any issues?
And the court in Fitchner in footnote 8 did address this, that simply by pleading not guilty, that essentially all the issues are in essence contested, but for purposes of analysis for plain error, when we're looking at a contested issue and whether that affects the fundamental fairness of the trial, whether that rises to plain error, that is when there is evidence in the record that the defense does not address. That's the distinction that this court has drawn in the past, and I encourage the court to apply that again.
I'm not sure I fully understand that. So did that answer mean to say that if one stands on a general denial that he can never succeed on a plain error challenge?
He can succeed. If one stands on general denial, one has to argue that or point to evidence, not just through argument, but through argument or also through cross-examination. It's not simply the entry of the not guilty means that all issues are contested. It's looking and examining the trial. What arguments were made? What evidence did the prosecution argue? What evidence did the defense point to? Otherwise, if we wouldn't have a plain error analysis. If everything were contested, then we'd be looking for a perfect trial. And that doesn't always happen because the defense is free to craft the types of arguments that are advantage to the defense. If the defense wants to pursue an affirmative defense, necessarily that they're not going to address certain elements. If the defense wants to concentrate on an identity defense, they won't concentrate on other elements. That affects what goes to the jury, what the jury is considering, and that affects whether certain instructions affect the fairness of the trial, whether they receive those instructions or not. In this case, the issue of sexual penetration, the definition was not given. This was a sexual assault case. The definition of sexual penetration was not given to the jury, but that was an issue that wasn't contested at trial. Within sexual penetration, part of that definition is sexual intercourse. The victim in this trial did testify that she had sex with the defendant. She said she basically had sex. She specified when the prosecutor asked, did that mean he put his penis inside you? She answered yes. Then on cross-examination, she also stated that she had sex with the defendant. And even when her father was cross-examined on the stand, he said that he had confronted the defendant. The defendant told him he and the victim were friends, that they had intercourse, but the victim had told him he was 18. And indeed, that was the defense that was pursued throughout trial. From opening to closing, even through cross-examination, the defense hammered in on the theory of defense, which was that the defendant had the affirmative defense that he thought the victim was over the age of 18. And so therefore, sexual penetration, that issue was not contested. The district court found, and defense argues, that by pleading not guilty, that means that sexual penetration was contested. That's not how the case law analyzes it. If you look at the cases of Aumann, which found a contested issue, the Fitchner case, as well as the Cowden case, what this court has looked at in the past is evaluating the arguments made by defense, the evidence cross-examined, or the evidence brought out, and whether that goes to an issue. That's what makes it contested. And especially when there's an affirmative defense. An affirmative defense essentially, not totally, but essentially concedes the element because it's a justification. This happened, and I was justified in my actions because, in this case, the argument for the jury was this happened, but the defendant was justified because he was mistaken as to age. That was the defense's theory.
What does essentially but not totally mean?
It means that the prosecution's obligation to prove every element of the offense is not obviated by the defendant's affirmative defense. There still has to be some evidence in the record. The Cowden case really illuminates this. In that case, there were 8 counts of theft, 8 different victims. One of those counts, this court found that a failure to give a jury instruction on value, that because the evidence at trial as to that particular victim didn't meet that value threshold, that was actually reversible. That was plain error. But on the other counts where there was evidence at trial above the value threshold, even though that definition wasn't given, that was not plain error. So that illustrates the difference in the record, of what has to be there in the record to show that an issue is contested.
But I can't remember. Was there a theory of the case instruction in this case?
To be honest, I don't remember either. But the affirmative defense was very clear from the start in both opening, and that affirmative defense was given as well, directly following the elemental instruction in this case. So, evaluating the arguments of the defense, the evidence the defense pointed to, and looking at the evidence of sexual penetration that was in the record, the victim testifying about there being about sexual intercourse, as well as her father testifying to the defendant's admissions that there was sexual intercourse, and that evidence not being rebutted by the defense. Evaluating that, I'd ask this court to conclude that that issue was not contested, and applying case law reversed the district court's decision. If I could reserve the remainder of my time.
Good morning. May it please the counsel. My name is Elizabeth McClintock, attorney registration number 25990. I represent the respondent, Mr. Lozano Ruiz, in this matter. I'm concerned about some of the arguments that were made by the state in their opening to the court. From the beginning of this case, Mr. Lozano Ruiz entered a not guilty plea. He made no statements. He made no admissions. We have an allegation that the father of the alleged victim had statements made to him. However, no documentation about that, no time, no place, no additional corroborating information that that ever occurred. But we did have, from the very beginning, defense counsel telling the court, telling the prosecutor, they have to prove every element of the offense. The prosecution didn't even want the jury to hear about the affirmative defense in opening statements by the defense because they said, well, they have to put on evidence that it's justified in being given first. And defense counsel pointed out, well, technically, too, they have to prove that any sexual contact occurred. If you look at defense counsel's opening statement, yes, he talks about the age and talks about how the complaining witness misrepresented her age on the alleged means of contact, which was on Facebook. However, if you look at his opening statement as well, he talks about the veracity and credibility of the complaining witness, how her statements don't make sense, how they're contradicted, and later on during the cross-examination, he goes into detail, cross-examining her not only about her age, but also about when she disclosed this contact to her father, what she did with that information, how these contacts between Mr. Lozano Ruiz and her took place, the fact that she had deleted all evidence of those contacts in the form of, she said, on Messenger from Facebook or text message, that she had deleted all of those. There was a discrepancy about how many times, supposedly, she had had contact with the defendant. There were a number of discrepancies in her testimony that were brought to light. And not only was that brought up, but also in regards to her credibility and veracity, went towards her blackmailing of the defendant.
Let me just come at this a slightly different way. Okay. If the issue in front of us was sufficiency of the evidence, would you agree that the evidence was sufficient to prove penetration?
No,
okay,
I would not.
Tell us why not.
I would not. Because of the fact that, first of all, the only information we have about penetration is that she had sex with me. She said, he had sex with me.
And he put his penis inside me.
Well, she did not say that. The prosecutor said that, and then she agreed with that. And there was never any information about where exactly, supposedly, his penis was put inside of her. And that is where the district court came down with the fact that without giving the instruction and the definitions of what sexual penetration are or sexual intrusion are, that the jury was not properly advised as to the elements of the offense.
Doesn't that, well, go ahead, please.
Sorry.
Well, it just seems to strain credulity a bit, right? Inside of me, even in the absence of a definition of penetration, that's somehow confusing?
Particularly immediately following her saying we had sex.
Well, except there was no foundation laid as to what she believes sex was. There was no foundation as to where exactly inside of her that meant. And without defining that, no, we cannot say definitively that the jury knew exactly what she was talking about. That is typically why the follow-up questions are asked in any kind of sexual assault case of, when you say, he put his penis inside of you, where exactly did that occur? These are elements of the offense. These are things that have to be proven by the prosecution beyond a reasonable doubt. And when they don't ask those questions, we cannot make the assumption that the jury unanimously decided and knew what they were deciding upon, especially when they aren't properly instructed as to what elements they're supposed to be looking at.
I guess my concern is that I'm struggling to follow the trial court's logic here. How an instruction would have in any way changed or altered or clarified the victim's testimony. She testified, we had sex. She acknowledged yes in response to the question, he put his penis inside you, yes. How does that description of intercourse in any way create confusion for the jury around sexual penetration? They understood that the element they needed to find was sexual penetration. So how does the instruction somehow clarify her testimony.
Well, I think it would go to not only clarify her testimony, but it would clarify for the jury what exactly sexual penetration meant under our statutes.
Well, the
which
first
was-
word is sexual penetration means sexual intercourse. That's why I asked you about sufficiency of the evidence. I'm having trouble understanding how, reasonable jury, giving the prosecution all the benefit of the doubt, how we would say that was not sufficient.
Because she had just said that they had sex. They did not say that they had sexual intercourse. And without knowing what in her mind sex meant, we cannot say that it definitively meant sexual intercourse.
And that's even if we give the prosecution the benefit of the evidence and all the inferences from the evidence, you would say that wasn't enough?
Well, I would say no. And unfortunately, and that's not the issue, unfortunately, we're dealing with here today.
Well, the reason
which
I
was-
asked is because I do think it's relevant if the evidence was sufficient on a plain error analysis. So anyway, that's why I was asking. It just strikes me as relevant to plain error.
And I would state for the court that no, I don't believe that it is sufficient without having more information and without properly instructing the jury that it was sufficient evidence in order to prove the elements of the offense beyond a reasonable doubt.
But here we don't, sorry.
Go ahead.
We don't have to speculate, right, about what she meant about, did you have sex with him? Because she was specifically asked in a follow-up question, did he put his penis inside you? And she said yes.
Except that we don't know where.
But doesn't the definition of sexual penetration include, not to be graphic, mouth, anus, vagina?
Right, and without speculating, you wouldn't know where that would have occurred. And as the district court pointed out, it could have meant, and it has to be an actual penetration inside of the vaginal opening, things like that.
Actually, it says however slight, so it makes clear that it barely,
Right, but it still has to be some. And there has to be a showing of exactly where that was. And as the district court pointed out, and the reason why we shouldn't have to be arguing about that would be that the follow-up questions should have been asked. And the definition should have been given to the jurors so they could be definitive in making their decision.
I
Ms.
don't,
McClintock, oh, go ahead, I'm sorry.
Sorry.
What's your recollection of what your client said to the victim's father? Did he not use the phrase sexual intercourse?
And, Your Honor, my understanding, and first of all, I wasn't the trial counsel in this case. So my contact with this case and with the defendant has been through the appellate record. My recall of the record was that supposedly he had said that they had had sex or something of that nature. However, then when the father was making postings online, he claimed that there had been multiple times that this had occurred, but then he said on the stand that day at trial that he hadn't heard that there had ever been really anything like that. He had only heard that morning that that had occurred. There was inconsistencies all along in regards to both CY's and SY's testimony.
Was there a theory of defense instruction given?
No, Your Honor.
What evidence do we have in the record that when she said she had sex with him and that he put his penis inside her in relation to having said she had sex with him, that she meant something other than what is ordinarily understood to mean I had sex or she had sex with someone? What evidence is there in the record for us to conclude that she meant something different than the ordinary meaning of those words?
Well, I would, I guess, reverse the premise and say, what evidence is there to support that actually means what the definition requires? And, that's the concern that I had when I heard the arguments before. The defense does not have any duty to put on any evidence or to put on any defense. I don't know how many trials I've sat through where a judge has gotten up and said, the defendant can stay there and not say a word.
Well, I wasn't asking about the statutory definition or the definition of the instruction that was not given. I'm asking about ordinary meaning of words. The district court judge appeared to assume or speculate that the victim may have meant something other than what everyone understands sex means. And I'm asking, what evidence is there in the record for us to make that finding?
But what evidence is there to state that that is the ordinary and plain meaning and that's what everyone assumes it means? I mean, and that was the point that the district court made in saying that the reason why we have these instructions and the reason why it's important to tell the jury about this is so that there isn't any question about speculation. And obviously, we have one district court judge that said it isn't clear to me what exactly she meant.
Well, let me come at this a slightly different way. I mean, Miller does say, failure to instruct the jury does not constitute plain error where the subject is not contested. It seems to me the rule you're asking us to adopt is if there is a general denial, then it's contested. So every jury instruction or where an element or a definition is missing becomes plain error. We're subject to that if we have a general denial. Help me understand what you think Miller means and what's contested for purposes of plain error.
Well, in regards to this case, I can tell you exactly what was contested. In regards to other cases...
I'm asking for the general rule.
Right. I think the problem is if you have a situation where a defendant doesn't put on any defense at all, then I guess they're saying the argument is plain error can't be raised at all. Because if you're not putting on a defense, you're not raising any objections. So really, unless it's a jurisdictional type of issue or some well-settled area of the law where the court could have potentially sua sponte taken notice of that error, there wouldn't be any objection. So the only type of error that could be applied would be plain error. So in that case, basically, a defendant would be deprived of his ability to appeal anything that went wrong in the case.
So what do you understand Miller to mean?
Basically, in my mind, it means that you should be able to challenge under plain error these things that go wrong, even if defense counsel doesn't raise an objection to them. Now, and contesting an issue by saying, yes, I'm pleading not guilty, they are putting the state on notice that they are denying the elements of the charge of the offense. That means all of the elements of the charge of the offense, and that the prosecution has to meet their burden of proof beyond a reasonable doubt as to each element of the offense. That's what it means to me.
Could I very quickly ask that in a slightly different way? Rather than ask about what's contested or not, what's your understanding of when the trial court has an obligation to define a term?
I believe any time that it has been put into place, and I know that when you look at the model jury instructions, it gives you a roadmap of exactly which terms should be defined. And when they are statutorily defined terms, then yes, I think they have to give an instruction as to that.
Do you think there's any authority for that? I mean, maybe you could tell me what the authority is where we've said. So your rule is if there is a term statutorily defined, it's error for the trial court to not define it.
Yes, I believe so.
And why do you think that?
Because of the fact that our legislature, if there is a term that is not so widely understood, that they feel the need to put forth a specific definition for that term, then a jury needs to be instructed as to the meaning of that term under the law in the state of Colorado.
And do you think if a term is defined because it's not widely understood, but it includes a portion that is widely understood, and that's the only thing that's at issue in the case, that it's also error or plain error not to define that term?
I believe so, because of the fact that the statute has said, these are the definitions, this is what we mean by these definitions, and the jury needs to be told exactly what those definitions are.
And it's, just to clarify, your view is it's plain error in every case when the court doesn't give that instruction.
And I would say, I cannot come up with a case where I wouldn't argue that it was plain error. Yes.
Thanks.
Okay.
Okay, thank you.
I know my time is up. Thank you for your time. I appreciate it. And I ask that the decision of the district court be affirmed. Thank you.
Okay. Well, the court appreciates the arguments of both counsel.
She's got some 5 minutes left.
I'm sorry. Well, please, not on my account. Okay, thank you. In that case, let me say the case will stand submitted, and we'll be in recess until about 15 minutes. Thank you. Please be seated. We've scheduled a 1-hour argument in the case of Montjoy versus People. I see counsel have anticipated us and have already taken their places and are getting ready to go. You may have heard me, I've been warning everybody, or just reminding you that we record these things, so if you could announce yourself and say who you're representing to the microphone, and then present your argument fairly close to the microphone so we can hear it. But otherwise, we're ready to go. Counsel for petitioner, when you're ready.
May it please the court, Judd Lonis, registration number 33208, on behalf of Christopher Mountjoy. The Court of Appeals reached the wrong result because it asked the wrong question. It asked whether the jury would have found or did find that Mr. Mountjoy used a gun, or somebody died, or that he tampered with evidence. But those are not elements. Those are just plain ordinary facts. The legislature has not singled out those facts for increased punishment. Under Colorado's catch-all aggravator, the question is whether extraordinary aggravating circumstances are present in the case. That is the finding that the legislature has singled out for increased punishment. That is the element. Mr. Apprendi, I'm sorry.
Lonis, let me ask a question. You made a comment. You said whether there's extraordinary aggravating circumstances in the case or to the charge, because I think those are two different things. Because in this case, the court kind of found aggravating circumstances from the case for each different count. Do you understand my question?
Yes, he did. The court has to find that extraordinary aggravating circumstances are present, and then it may increase the sentence for any of the charges of which the jury has found the defendant guilty.
Okay, so not necessarily broadly for the case, but for each count.
I believe that's the case, Your Honor.
Okay,
Yes,
thank
just
you.
like any other aggravator must be proved with respect to the case.
Okay, thank you.
But Mr. Mountjoy was deprived of his constitutional right to a jury trial when the judge, rather than a jury, found that extraordinary aggravating circumstances were present in the case. It's just as surely as Mr. Apprendi was deprived of the right when the judge found that he acted with racial animus. Just as surely as Mr. Blakely was deprived of the right when the judge found that he acted with deliberate cruelty. And just as surely as Mr. George Wolt was deprived of the right when a 3-judge panel found that he acted in an especially heinous, cruel, and depraved manner, thus qualifying him for the death penalty under Colorado law. The mistake that the Court of Appeals made, and frankly the mistake that this court made in Lopez, was that extraordinary aggravating circumstances are different than any other element in the world. When a finding is an element, the Constitution requires a very specific procedure. The judge has the duty to instruct the jury on the definition of the element. The jury then considers the raw facts, the brute facts, the historical facts of the case, be it a gun, or somebody died, or the defendant was wearing a red shirt. Whatever the prosecution claims proves the element. But the jury must make the ultimate finding that that element has been proven beyond a reasonable doubt. So in this case, the fact that Mr. Mountjoy used a gun didn't increase his sentence one iota. If the jury found he used a gun, that would not increase the sentence. You could read Colorado revised statutes back and forth, and you will never find a provision that allows a judge or anyone else to double the defendant's sentence based on the fact that he used a gun to commit manslaughter. The finding that allows the increased sentence is that extraordinary aggravating circumstances were present in the case. That is the legal standard. And under a properly drafted statute, the judge would have instructed the jury on the meaning of extraordinary aggravating circumstances, and the jury would have decided whether, beyond a reasonable doubt, the prosecution's evidence proved extraordinary aggravating circumstances in the case.
Mr. Lawrence, if I can ask you, what do we do with Lopez? I mean, there's the footnote in Lopez where we addressed this exact statute and said the court can find the ultimate legal question of extraordinary aggravating. And then Cunningham, the U.S. Supreme Court cites Lopez with approval.
They don't. They merely say that it's an interim solution. That was 13 years ago, and it should give the court absolutely no confidence whatsoever. If the court will remember, in Walton, the U.S. Supreme Court found that the Arizona death penalty statute passed constitutional muster. A few years later, they found that it was unconstitutional. They did the same thing with Florida's death penalty statute. They found it was constitutional, or said it was constitutional, and did not. Well, it's distinguishable because they actually held the Florida one was constitutional rather than dropping a footnote. They later, in Florida v. Hearst, found that it was unconstitutional because the judge had to make a finding that extraordinary aggravating circumstances were present in order to impose the death penalty, even though it was based on findings that the jury had made. Now, in the case of U.S. v. Godden, which this court...
Before you go there, stay with the question about Lopez. Is it dicta?
The footnote?
Yes, absolutely is dicta. It's absolutely dicta. I mean, I know that my opponent in their brief said that the U.S. Supreme Court held that it was appropriate, but that is in no way correct. It's merely a footnote. It's entirely dicta. The court has not considered the statute and made any sort of holding about it, and frankly, I believe that if it were to consider the statute, it would find it clearly unconstitutional.
Well, can I just ask, it might be dicta in Cunningham. What about the footnote in Lopez in which the court said, we conclude that this determination is a conclusion of law, the extraordinary aggravating circumstances is a conclusion of law that remains within the discretion of the trial court if it is based on Blakely compliant or Blakely exempt facts?
That's my question, too.
That is absolutely entirely wrong. Okay, and I wish I think the court, Mr. Mountjoy could win if this court did not overrule Lopez, but Lopez is nevertheless wrong. And here's the problem.
I'm sorry, maybe I got confused. When you answered what was dicta, you were talking about Cunningham or Lopez?
Cunningham is dicta, yes.
Oh, okay, forgive me.
Yes, absolutely. The footnote in Cunningham is absolutely dicta. The court's misunderstanding in Lopez is it didn't consider the holding in United States v. Godden, which is, after all, the case that the United States Supreme Court cited in Apprendi for the fact that a defendant has a right to a jury trial on all elements of the offense. In Godden, the jury was asked to find whether the defendant made a particular statement to a particular federal agency. Under that current law, the judge decided whether those statements were material. Now, like extraordinary aggravating circumstances, everyone agreed that that was an element. However, the government argued that the element of materiality was different from every other element, that the judge could find it. The Supreme Court adamantly and unanimously ruled that that was not correct. A juror cannot be made a mere fact finder. The jury has to make the ultimate conclusion that an element has been proven beyond a reasonable doubt, even if it is a matter of law, even if it is a mixed question of fact and law, because the court recognized that no elemental finding is completely divorced from the law. The jury must always find that the evidence met a particular legal standard, so it's always a mixed question of fact and law. And that was, unfortunately, the Lopez court really got that wrong. And I believe that none of the parties cited Godden to the court, and it certainly didn't consider it in its opinion.
Well, what do you do with the fact that in Lopez, there's citation to Blakely, I think it's footnote 8. That passage from Blakely, I guess in your estimation, doesn't do anything to change your argument under Godden.
No, Your Honor, I mean, if you squint real hard, you can maybe come to the conclusion that the jury trial right applies only to factual findings and not elements, but I think we all know that it applies to elements. I'd like to give you an example. Maybe because extraordinary circumstances is just such a vague standard that I think it's kind of hard to grasp. But let's take a case of extreme indifference murder, okay? The prosecution would violate the defendant's right to jury trial if it merely asked the jury to find what the defendant did. Oh, did the defendant drive on a road? Did he weave between traffic? Was he going 30 miles per hour above the speed limit? And then the judge relied on those facts and decided as a matter of law that that was universal malice or extreme indifference. That would be a clear jury trial right violation, even though it's based on factual findings that the jury made, because the jury has not found the element. And indeed, the jury trial right could be completely eviscerated if the jury is merely asked to find facts and the judge is asked to make the finding of an aggravator or any other element.
Under our argument, Mr. Lonis, is 18.1.34016 unconstitutional?
Yes, it is. It absolutely is. There would be one instance where it could be constitutional, and that would be where the defendant understands he has a right to a jury trial, constitutional right to a jury trial on those facts, and gives it up as part of a guilty plea. And he could still do that, and in fact, there would be reasons why someone might want to do that. For example, if they were charged with a Class 4 sex offense, which is subject to an indeterminate life sentence, they might wish to plead to a Class 5 attempt sexual offense. Agree that the judge could aggravate the sentence. In his maximum sentence would be 6 years instead of 3. But that is the only instance when it may be constitutionally applied. Another example, let's say the defendant is charged with theft. While theft is taking anything of value, it becomes a Class 5 felony if the thing of value is more than $5,000. Well, what if the jury is merely asked to find the defendant took a diamond ring? And the judge finds that that ring is worth $5,000 and convicts defendant of the Class 5 felony. That's a violation of the jury trial right. The judge has relied on a finding that the jury made, but the jury has not reached the ultimate conclusion that the element is proven. Therefore, that's a violation of the jury trial right. The only way that the Court of Appeals decision can be affirmed is if this court finds that this sentence aggravator is different than every other element under the sun. And the U.S. Supreme Court has held time and again, sentence aggravators and elements are the same thing. Your Honor, I would like to move on to my argument about why the error in this case cannot be harmless. Just as the elemental inquiry has to be directed toward the ultimate finding that increases the sentence, so too must the harmless error inquiry. So, when deciding whether the court's error in finding extraordinary aggravating circumstances was harmless beyond a reasonable doubt, this court has to ask whether a jury would have found beyond a reasonable doubt that extraordinary aggravating circumstances were present in the case. Now, I stipulate that a jury would have found that using a gun to commit reckless manslaughter is a totally ordinary and not unusual way to commit the offense. I'll further note that in the trial court, the prosecution told the judge that it was not compelled to find that there are extraordinary aggravating circumstances in the case. It said you can go ahead and sentence in the presumptive range. Moreover, it only argued that the manslaughter conviction was aggravated until the court suggested that maybe it wanted to aggravate the other two also. And finally, the judge said it was a very close question in the trial court. And then finally, Your Honor, on appeal, the state does not even argue that the error could be harmless beyond a reasonable doubt. Never once makes that argument. It argues that this is the plain error standard is present in this case, and based on that premise, it says that Mr. Mountjoy can't meet the plain error standard. But it never once argues that this error could be harmless beyond a reasonable doubt under the constitutional error standard. I actually think the court can't even reach whether the error was harmless beyond a reasonable doubt because this was never charged. He was never given pre-trial notice. Now, the application of the constitutional harmless error standard depends upon whether an error was a trial error. And I believe that this is not a trial error in this case. I fail to see, and the state has failed to point out anything Mr. Mountjoy could have done at trial to prevent this error. He had no idea that the extraordinary aggravating circumstances were at issue. He had no cause to ask the jury, to ask the judge to give the jury an instruction on it or a verdict form. Here, as in Medina, as in the U.S. Supreme Court's case of Elaine, A-L-E-Y-N-E, the error occurred after trial. And just as soon as the prosecution sought aggravation, Mr. Mountjoy objected. He asserted his constitutional rights to jury trial, and he objected under Blakely and Apprendi. Under these circumstances, it cannot be trial error. The error all occurred at sentencing, when the judge imposed a sentence for something the prosecution had never before asked for. Didn't ask the jury for it, didn't charge it, it just asked the judge to do it.
While you've paused, Mr. Lonis, so if we agreed with you, what's the remedy that you seek? Is it just the aggravation goes away? Is there a remand for a further hearing, or what?
I do not believe under any circumstances Mr. Mountjoy's sentence may be aggravated. This court should remand with instructions for the trial court to impose sentence in the presumptive range. That's what it's done previously when a trial court has erroneously imposed an aggravated range sentence.
Mr. Lonis, the people argue that if we conclude that the statute is unconstitutional, there are a couple of different approaches we could take. One is to eliminate the requirement of sentencing within the presumptive range. The other is to say that the jury finds aggravating circumstances. Do you have a view, if we conclude that the statute is unconstitutional, about what we should do?
Yes, I do, Your Honor. I think the court should simply strike the offending position. Okay, the first, while taking the second option first of just allowing the jury to find extraordinary aggravating circumstances, it is true that a properly drafted statute would actually ask the jury to find extraordinary aggravating circumstances. Okay, I believe that finding is frankly so vague that it'd be hard to put to a jury. But the vagueness is an additional constitutional problem. It doesn't excuse the prosecution from giving the defendant his jury trial right. So I don't think the court, under our tripartite system of government, the court cannot rewrite the statute. It can find a statute unconstitutional. So I think if the court, it may just be one or two words crossing out court and writing jury, but it is such an important change that should be left to the legislature to decide. The second remedy is just to make, I guess it would be to make upon every conviction, every defendant in the state would be subject to sentencing under the aggravated range. I believe that's what they're suggesting. That doesn't make any sense to me. Again, that's the legislative prerogative. Furthermore, if the court just struck the offending position, subsection, there are many other aggravators that aren't affected by this decision. The defendant may have his sentence doubled if he's on parole for a felony at the time he commits the offense, probation for a felony. There's the crime of violence provision, where under certain types of crimes, if the prosecution pleads and proves that the defendant used a deadly weapon or caused a death during the commission of the crime, the defendant's sentence should be doubled. Every one of those provisions would be rendered meaningless if upon a mere conviction, the defendant was automatically subjected to an aggravated range sentence.
Could I ask you a question, Mr. Lewis? Do you think it's under Apprendi, Blakely, it's up to the legislature to decide what the maximum sentence is for any given crime?
Yes.
And so if the legislature defined the sentence, the maximum sentence, as what is now the double the presumptive range or the end of the aggravated range, extraordinary aggravated range, would that be constitutional?
Yes.
But you don't think they've done that?
They have not. And, Your Honor, I'm picking up hints of your concurrence in Lopez. Your Honor, first I would like to point out that the state in this case has agreed that it's an element. They have not made an argument similar to your reasoning in Lopez.
I thought the brief suggested that if we were to agree with your argument, one solution would be to, in effect, adopt the alternate opinions position in Lopez to solve the constitutional problem.
I don't think that they were saying that that was an alternate interpretation. I think they were asking the court to essentially rewrite the statute. Now, if you look, now I understand your position, and frankly, Chief Justice Coates, I can see why saying every sentence is subject to an aggravated range, I mean, every crime is subject to an aggravated range sentence is very convenient. And perhaps you even adopted that position because you realized the grave Apprendi problems with the majority's opinion in Lopez. However, I think the structure of Colorado's sentencing scheme makes that position untenable because the statute says every person shall be sentenced within the presumptive range unless X, Y, and Z are proved, okay? And as I said before, if every crime is subjected to a sentence in the aggravated range, what's the purpose of the crime of violence provision? What's the purpose of per se crimes of violence, which passes constitutional muster, by the way? This legislature simply says if defendant's convicted of this crime, he's automatically subject to a sentence of twice the presumptive range. I mean, really, the entire structure of the sentencing scheme does not make the type of sentence it should if an aggravated range sentence is available.
And I guess that's
case.
really what my question was about. I didn't mean to be asking you about whether we should adopt what the position was that was rejected in Lopez, but rather you seem to be making a policy argument about the purpose for an aggravated range, and I simply wanted to find out if you agreed that was perfectly within the legislature's determination what the maximum sentence should be.
Yes, absolutely it is. But when the legislature says that this is the maximum sentence, but if an additional finding is made, the maximum sentence is doubled, they have created an element. And an element is subject to the Sixth Amendment, the Due Process Clause, and the defendant has a constitutional right to a finding that that element has been proven beyond a reasonable doubt, and a jury must make it.
And maybe I could pick up on that just a little. Because you gave examples of other things that for a specific finding, the range would be double if you're on parole or whatever it was. Is that different in your mind from the situation in which the legislature does not specify something that would double the range, but simply indicates that the court can exercise its discretion within a broader range based on whether it considers even factors that were elements to be extraordinarily aggravating?
I think they could do that, but 18.1.3406 does not do that, okay? Because looking to the statutory language, if I may have a moment, please. It says, imposing a sentence of incarceration, the court shall impose a definite sentence which is within the presumptive ranges unless it concludes that extraordinary aggravating circumstances are present and support a different sentence which better serves the purposes of this code with respect to sentencing. Okay, so if the legislature just opened up upon any conviction, the range would be doubled, and the court could consider the sentences of the code with respect to sentencing only, and that was the only factor that guided its decision. That would be constitutional. But here, it's requiring the court to make a finding of extraordinary aggravating circumstances, that elemental finding, and in addition, make a policy judgment. And the extraordinary aggravating circumstances finding is not just a policy question, it's a judgment. The jury should be able to look at the facts of the case, what the prosecution decides that they think are aggravating, and the jury has to make that qualitative judgment, that moral judgment. Are we going to convict the defendant of this aggravated crime? And that's what did not happen in this case. And that's what the statute doesn't allow the jury to do.
Perhaps just one follow-up. Taking your argument there with regard to what should be for the jury rather than the judge, finding extraordinary, that it is an extraordinary aggravating circumstances, or that there are, because there is no one thing that's specified that would raise the range. Do you think the jury then, by Apprendi Blakely, also should have to be the one to set the length of the sentence?
No.
What's the distinction there?
So long as the legislature says upon a conviction, this sentence is available, the jury just merely needs to find the elements that amount to that conviction. When the legislature says the defendant shall be receive increased punishment upon an additional finding, the jury has to make that finding too beyond a reasonable doubt. But nothing in the Constitution requires the jury to make the decision about where defendant should be sentenced within the range that is available upon conviction.
Or upon aggravation?
Right, the jury has to find the aggravation, but they don't have, they don't. The constitutional wrong here was that the jury did not find extraordinary aggravating circumstances. It was not that the jury didn't fix the punishment within that aggravated range. If the jury had found extraordinary aggravating circumstances, if the statute allowed them to do that, then it would have been proper for the judge to decide where Mr. Mountjoy's sentence should fit within that range.
In terms of the notice question, how would you see that playing out if, in the context of an interrogatory, for example, what does that look like? Hello, jury, let us know whether you find the presence of extraordinary aggravating circumstances?
Yes.
And, okay, and is that request for an interrogatory sufficient to place the defendant on notice under your other argument?
No, I believe that they should allege extraordinary aggravating circumstances in a charging document. The state courts are, frankly, they're split as to whether the defendant that extraordinary aggravating circumstances must be charged in an information. You know, many courts, so many state legislatures have written statutes that require the prosecution to plead it in an information, much like our crime of violence statute. Where that doesn't occur, virtually every state court will say, well, he may not have a right to it being in the charge, but he has a right to pretrial notice, so that he may request a jury instruction on the matter, so that he may defend against it.
Are you envisioning that there'd be bifurcated proceedings in some of these cases? Because obviously some of these aggravating factors would not be admissible on the merits, right, on the trial on the merits. So for example, somebody's been convicted 6 times. Somebody has 6 felony convictions, and the prosecution wants to use that as an extraordinary aggravating factor. Is that something that they would have to submit to the jury in some sort of bifurcated proceeding?
In that case, we have the habitual criminal statute, which does require pretrial notice and a hearing outside the presence of the jury. The judge can make that finding because it is the simple fact of a prior conviction. The problem with this statute, and where Lopez erred, is that the prior conviction, the judge looked at a prior conviction and said, aha, that's an extraordinary aggravating circumstance. The prior conviction did not increase his sentence. It was the judge's conclusion that the prior conviction was an extraordinary aggravating circumstance. And as Justice Elena Kagan has said, there is the constitutional rub. The prior conviction exception applies only to the simple fact of a prior conviction.
So in the context of the habitual offender statute, since prior convictions are Blakely exempt, what you're saying is the fact of 6 prior convictions, which is a Blakely exempt fact, that's okay for the judge to find because it's finding that he's a habitual criminal, not that that aggravates.
Yes,
Okay.
when the simple fact of a prior conviction increases the sentence, that is the prior conviction exception. So under the possession of a weapon by a previous offender, the classification jumps a notch if he has a prior conviction for possession of a weapon by a previous offender.
And that's, again, Blakely exempt.
That is Blakely exempt. That's the prior conviction exception. But when the judge has to look at a bunch of prior convictions and make and not just find the fact of the prior conviction, but make an additional finding such that the defendant is incorrigible, or his crimes are becoming increasingly serious. The state courts almost universally hold that that finding falls outside the prior conviction exception, because unlike Lopez, everyone else holds that the fact of the prior conviction is the exception, is the simple fact of the prior conviction, not facts relating to or regarding from or regarding or surmised from prior convictions.
But to answer Justice Amore's question, in many instances, there would be a need for bifurcation as a practical matter.
If the jury were asked to find, right, and that's, the legislature may choose to do that.
Right, we're sort of imagining a different statute, right? But right now, the jury doesn't, there was no bifurcation because the jury can't make this determination.
It requires the court to make the decision, which is the crux of the whole constitutional problem. If the legislature were to rewrite the statute, I submit that it would, and I'm out of time, I submit it would be unlikely to make such a vague aggravator. It would probably do what Lopez suggested in its interim solution and say that the legislature can come up with specific aggravators that increase the sentence.
Other questions? Okay, you are out of time.
Thank you. I'd ask that you reverse the sentences and remand for sentencing within the presumptive range. Thank you.
May it please the court, my name is Brock Swanson, attorney registration number 39116, and I represent the people of the state of Colorado in this matter. In my answer brief, I tried to anticipate all the different ways this case could go, but I want to start off by clearly stating the people's position for how this case should be resolved. This court should apply its opinion in Misenhalter versus People and find that there was no error in this case. As in that case, the trial court in this case effectively used the defendant's concurrent convictions to impose an aggravated sentence. And because there is no error, there's no reason to consider whether any hypothetical error would be harmless. The defendant asked this court to instead overrule its prior precedent, in particular this court's opinion in Lopez versus People, upon which all of this court's subsequent Blakely cases, including Misenhalter, are premised. Before even entertaining that argument, I'd like to touch on the threshold issue necessary for the defendant to prevail on that claim, and that is that the argument must have been preserved. Because if it was not, the defendant cannot establish plain error because error was not and is not obvious. Here in the trial court, the defendant, during his arguments, explicitly asked this court to consider and apply Lopez. I think that simply cannot be interpreted as preserving his argument on appeal that the trial court erred in following Lopez. And for that reason, this court should not find that the defendant's argument on appeal preserved and should not address them.
What about the point they make in the reply brief about the gun? No, they found gun, but they didn't find extraordinary aggravation. What about that exchange? Doesn't that suggest preservation?
I think the entire argument read, particularly in context of the reference to Lopez, is best understood as the argument that those facts, that there weren't compliant, Blakely exempt or Blakely compliant underlying facts as were required by Lopez.
Well, I'm looking at page 35 of the transcript.
Sure.
34 and 35. We object to the aggravated sentence being sentenced in the aggravated range on two separate grounds. One is due process, and under the U.S. and Colorado constitutions, and then goes on and says, the jury did not find any of the facts that Ms. Houston cited as extraordinary aggravating factors.
Right.
That's not preserved.
I think that preserves the argument. What Lopez held, and we'll obviously get there, is that there need to be underlying facts in order to support the conviction, an aggravated sentence. And I read that argument as saying there weren't facts, because it says facts, that support the ability to impose an aggravated sentence.
Then the court says, what about the use of the gun? Isn't that considered an aggravating factor? And the attorney goes on to say they didn't find that that was an aggravator. They found it was use of a gun. Again, it seems to me that that's pretty clearly saying to the court the jury ought to be finding that this is an aggravator.
Obviously, you can disagree, but I think the defendant's clear reference to Lopez and asking them to apply it informs the rest of its discussion about what it is asking the court to do. I don't think that the court here had a fair opportunity to consider and address and was aware and cognizant of the defendant's argument that he is presenting on appeal, and that the entire discussion reflects that was what the trial court was on notice of from the argument and what was addressed. But if this court does reconsider Lopez, I'd argue it should be affirmed. And I think this is really important that in Lopez there were two issues. The first was a question of statutory interpretation to determine what Colorado's aggravated sentencing system is, and the second was whether that system could be constitutionally applied under Blakely. And the proper interpretation of the statutes was debatable. Indeed, the people they argued for a different interpretation. We argued for a different interpretation in there. But what is not debatable is whether the interpretation that it adopted can be constitutionally applied, because it is exactly the system that the United States Supreme Court addressed in Blakely.
Go ahead. Sorry. Let me ask you, Mr. Swanson, and good morning to you. Do you agree that a sentence enhancer is considered the same as an element, that Apprendi in other cases said that?
I think so. I mean, I may have to unpack that further, but...
All right, so if this is a sentence enhancement and it's an element, how is this case different from Godin? I mean, I think your argument is, let me just be clear, I think your argument is essentially the judge gets to make the ultimate legal conclusion. That strikes me as exactly what the Supreme Court rejected in Godin, but push back.
Sure. So, and this is exactly where I'm going. I think we need to be really clear about what it is that Lopez held is the statutory interpretation for our system. And the key there is that what they held is that the only requirement to open up the aggravated range is that there be an underlying fact. And I can get the language from Lopez. It's not the footnote that we're relying on there, but the statement that says, under that section, the existence of a constitutionally permissible aggravating or mitigating fact widens the sentencing range on both the minimum and maximum ends. The sentencing judge then has full discretion to sentence within this widened range according to traditional sentencing considerations. And if that's not, sorry.
No, go ahead, sorry.
If that's not clear enough, I'd point this court to the decision in De Herrera versus People, which came out shortly after that. And there the court said very clearly, the existence of a prior conviction opens the aggravated sentencing range. And the full sentence there is, although the existence of a prior conviction opens the aggravated sentencing range, the trial judge is not required to impose a sentence within that range. So the interpretation that they gave in Lopez is not that that there ever has to be a finding of extraordinary aggravating circumstances in order for the aggravated range to be available.
So could you address then Mr. Launis's argument? He said the fact here, the use of the gun, the tampering with evidence, the fact that someone died does not, under the statute, our statute, increase the sentence. The sentence says that the range gets increased by virtue of extraordinary aggravating factors. What do you, I mean, I guess I'd ask you to respond to that.
I would say that Lopez rejected that interpretation.
Yeah, but tell me what U.S. Supreme Court case best supports you.
Blakely would be my short answer to that. In Blakely, the court held that the element that the right to a jury trial attaches to in a sentencing scheme, exactly like ours, where there is an underlying fact that opens up the aggravated sentencing range, and then the trial court has discretion to impose an aggravated sentence either within that range or without that range, is not that the jury trial right attaches only to those underlying facts. That was the system that they considered there, where it had both of those things. It had an underlying fact that opened up the aggravated range, and then a trial court's exercise of discretion about whether it was going to sentence within that range, and they held the jury trial right attaches to the underlying fact and not to the trial court's exercise of discretion within that range. And
Let me just ask you one more question, but why does the underlying fact here opening up the extraordinary sentencing range or the aggravated range, if the underlying fact is use of a gun? What in the statute opens up the aggravated range on that?
So I'll give you two answers to that. The first is just that that's what Lopez interpreted it to mean. That was the interpretation that it gave in order to render what was left constitutional. To render what the provision constitutional is that's what it interpreted it to mean. And as I said, I think it is debatable, and it was debatable, but that's what they decided it means, and that what they decided is constitutional. So what the defendant is really asking this court to do here is to adopt a different statutory interpretation of the provision than the one that they had in Lopez. And he's asking this court to adopt an unconstitutional interpretation, to adopt a different interpretation and say that it must be interpreted in an unconstitutional way. And this court has a duty to interpret a statute to be constitutional, to avoid any unconstitutional interpretations.
But we also have a duty to acknowledge the Supreme Court Sixth Amendment cases. And I guess it seems to me, so just taking the use of a gun. So the jury found that a gun was used, certainly, because they found that he dangerously fired the gun. I would be curious, I don't know the answer, I doubt you know the answer. How many manslaughters in Colorado are committed with a gun? My guess is it's a lot. My guess is a lot of the manslaughters in Colorado are committed with a gun. So that means every time a manslaughter is committed with a gun, that's automatically can be an aggravated sentence?
Well, in this case, under Meisenhalter, what the court was doing here, what opened up the range is the fact that he had a prior conviction. That alone, period. He had a prior conviction. That opened up the range, that made its choice of a sentencing, that range Blakely compliant or Blakely exempt. That was the factor that was doing that. And because the court was relying on the facts of those prior convictions, it could sentence him within that range. If this court or any court was to disagree with the trial court's conclusion that it was extraordinarily aggravating, that it warranted a sentence in the aggravated range, that would be an issue that can be appealed regarding the court's exercise of its sentencing discretion. And that it has not been appealed in this case.
Did the Court of Appeals Division rely on the prior convictions? My memory is when they recited the aggravators, they didn't, but I could be misremembering.
So what the Court of Appeals did is that the majority, the two-judge majority, just assumed error and addressed it only on harmless error grounds. It didn't say that there was error, it just assumed it. And then in a concurring opinion, Judge Jones opined that there was no error because of...
And my question may not have been clear, I apologize. And the Court of Appeals lays out its understanding of what the trial court did and looked at as aggravators. For example, on manslaughter, the court found it aggravated because use of a weapon, tampering with evidence, admitted firing 8 times, fired into a car with people, and fired while the car driving away. That was at least the Court of Appeals' understanding of what the basis for the trial court's aggravation, not the prior conviction.
Right, and that is exactly the situation that we had in Meisenhalter, where the court had considered the things that were established by the prior convictions. And what the court said there was that it had essentially considered the prior convictions. And the fact that the important thing is that the facts had gone through the jury trial process, and that's what made them eligible for the prior conviction.
The prior convictions are the convictions in this very case?
Yes. And that was the holding in Meisenhalter, that the conviction occurs, well, a conviction is a term, and it means that occurs when the guilty plea is accepted or the jury verdicts are accepted by the court and entered. And
I don't understand how that,
Sorry.
and maybe I was just missing it.
Sure.
So if you're convicted in this case, that becomes a prior conviction for aggravating purposes?
if you have more than one conviction that arose out of this case, yes.
Okay.
Can I ask you to talk a little bit about Hearst versus Florida, the 2016 Supreme Court case, so after Lopez and after Meisenhalter.
Right.
See, the court said if the jury if the judge itself, if the court itself weighs the aggravating and mitigating circumstances to make the ultimate sentencing determination, that violates the Sixth Amendment. How is that not kind of squarely at issue here?
If I'm remembering correctly, in Hearst, the issue was that they had a system where there were, the jury made recommendations and it found these things and it made a recommendation, and then the court made a subsequent independent evaluation of the facts and balanced them. And in death penalty cases, we have these special provisions about the things that have to be considered before you can impose a death penalty case. That require a number of them, and a number of them to be done by the jury. And the state was arguing in that case that, well, that had essentially been done by the jury when they were recommending it. And they rejected that essentially on a statutory interpretations ground that, no, the statutes in Florida clearly said that the court had to make an independent evaluation. And the court couldn't do that because those are things that have to be in a death penalty case done by the jury. But what I think is important in that case is that there's an additional step after you find all of those factors support a death penalty, that the court still has discretion whether or not to give it. And they did not say that that issue would be an issue that would have to be given to the jury, that the court still, once all of the statutory factual prerequisites for the sentence has been imposed, it is then okay for the trial court to have discretion to choose between different remedies. And I'd point this court also to, in Elaine, the United States Supreme Court case, they very clearly reaffirm this idea that judicial fact-finding is okay within a range, as long as the range has been authorized by the facts that are found. It says, we have long recognized that broad sentencing discretion informed by judicial fact-finding does not violate the Sixth Amendment. All that matters is that the range has been authorized by some set of facts, and then once that set of facts has been satisfied, then the court can exercise fact-finding and discretion within that. And that's really what we have here. That's what Lopez interpreted this system to be, is a system where there are facts, aggravating facts. Any aggravating fact opens up the aggravated range. And then the court has discretion to sentence within that. It's just, it's ordinary, normal discretion. It's not a mixed question of fact and law. It's not an element. It's just ordinary sentencing discretion within a range.
But it seems that the threshold to get you through that door is the determination that it is in fact aggravating, or in this case, extraordinary. And it seems that your opponent is saying, it doesn't matter that the jury found in companion conviction the use of a gun, et cetera, et cetera. The question to open up the door here is whether that was extraordinary. Why does the judge get to do that instead of the jury under Apprendi and Blakely?
My first answer is, again, that's how Lopez interpreted the statute. It does not have to find that it's extraordinary. That's not required to open up the opening. They interpreted the extraordinary portion of the statutory language as only being that we're giving the court discretion to impose on that, but not to require it to impose the sentence in that range, if that makes sense. It's any aggravating fact. It does not have to be an extraordinary aggravating fact to open up the range. And the clearest in this context is in De Herrero Estelian, where they're saying any prior conviction. If you have a prior conviction, the aggravated range is available. There doesn't have to be any finding that it's extraordinary. There's no other findings that are required in order for the aggravating range to be open for the trial court.
Okay, so in this case, we have separate convictions as part of the same case. What if we just had one count? If we just had a single count, who gets to decide whether a particular fact present in a case is aggravating or extraordinary to open the door in that situation?
Well, the court through case law has listed the sort of things that it counts as aggravating facts, and the statute also includes some guidance on that issue. So the one that's clearest is that prior convictions are aggravating facts, and then it's also said, find that in here. But it's not entirely open-ended, but some of the courts, sorry if I'm jumping here, some of the other courts, jurisdictions with the similar systems here, because the same system is in place in a lot of places, have just expressly said it's like any fact. If there's any Blakely compliant or Blakely exempt fact, then the range is potentially open, if you have any fact. And then it's just a matter of addressing the trial court's discretion, whether it abused its discretion or in imposing whatever sentence that it decided to.
So that means, I mean, it seems to me that that means that what you're really saying is that the words in the statute talking about a presumptive sentencing range are meaningless, because any Blakely compliant fact, that's anything the jury found that the judge wants to say, oh, well, I find that to be aggravating. So are you essentially arguing that the range is actually up to the aggravating range?
And no, I'm not arguing that, because that was the part that the Lopez did not agree with, is that any fact, because it couldn't be a fact that was inherent in that single conviction itself, if that makes sense. So if this defendant had only been convicted...
In the single count context, then, that means...
Right. If he was only convicted of a single count, and there were no Blakely compliant or Blakely exempt facts other than the findings of the elements in that case, then you wouldn't be able to impose an aggravated sentence.
And that's because you don't have a jury finding of anything other than what's required for the conviction?
I think that's right. I heard what you're saying. I'm sorry, I'm having a little trouble hearing. I get a little echo here or something.
Can I, while you paused a minute, I'm trying to just belabor this on Misenhelter. I guess I've never read it the way you do. In this case, all three convictions were entered at the same time, right?
Right.
I mean, wasn't the issue in Misenhelter that the guilty plea, the conviction entered before the sentencing, so you had a prior offense?
In that case, all three convictions had entered at the same time. They all entered in the same guilty plea.
But the court, I thought, said the conviction for the aggravated incest in that case entered before the sentencing for negligent child abuse, therefore that was a prior.
And I think that gets to partly, the term conviction is a term of art, and it means just the acceptance of the guilty verdict or guilty plea.
Right.
The judgment of conviction is the whole package together with the sentencing. So in that case, and it's a little unclear in that case because the fact doesn't matter given that, but he was resentenced on all of those offenses at the same time, if that makes sense. It was truly, they all entered on the same date when he pled guilty, and then it used one of the other ones to do it. It's the same situation.
I understand. Thank you.
Okay. I just want to provide sort of another way of thinking about the Lopez interpretation if this court is going to be reconsidering that. First, I want to say, if this court is going to reconsider it, the people maintain the statutory interpretation that we argued there and that was expressed by the concurring opinion. And if this court finds that the Lopez interpretation is not right or is unconstitutional, we would still argue that. And that interpretation is that that an aggravated sentence is permitted in all cases by the conviction alone, and the statutes only impose a procedural requirement for a more thorough explanation of the trial court's reasoning. They don't impose a substantive bar on aggravated sentences. But to justify the Lopez interpretation, I think another way to look at this is that the statute expresses the General Assembly's intent to give the entire issue of aggravated sentencing to the court. But under Blakely, some of that intent is unconstitutional, but not all of it. And so I think what the court did in Lopez is to say, okay, we know what the General Assembly intended here, wanted to give everything it could regarding aggravated sentencing to the trial court. And so it carved out the parts that are permissible under the constitutional law to give to the trial court and gave those to them, and the ones that it had to give to the jury, it gave to the jury. And this system that we have here, that they created here, or that they interpreted as for Colorado, follows that framework. It does it gives the things that the jury is required to find underlying facts that open it up to the jury, and it leaves for the trial court the discretion to sentence within the entire range once that has been opened up. And because the Supreme Court has said that's okay, and that's what the General Assembly intended to do, is to give everything it could to the trial court, that is a reasonable interpretation and constitutional interpretation of that provision. Sorry, it's a lot here. I guess I would then turn to in the event that this court does find that the system is unconstitutional and it cannot be interpreted in a constitutional manner, the remedy that this court would ask for is the same remedy that the United States Supreme Court imposed when it found that its system was unconstitutional, and that's the remedy in Booker of making the presumptive range advisory. That remedy would be preserve the General Assembly's intended sentencing range, its intended fact finder, its intended ultimate decision maker, and it avoids a lot of the numerous problems that are created by any other solution, such as we've talked. There's been some talk about need for bifurcated proceedings and giving issues to the jury that they might not be well positioned to make determinations about, particularly whether something is extraordinary. They don't have a background of seeing a lot of cases in order to make that kind of determination. I think this court could do that by simply excising the first sentence of Section 18.1.3 401 1BI, which is the provision that says, except as provided in the aggravated circumstancing and crime of violence provisions, a person who has been convicted of Class 2, Class 3, Class 4, Class 5, or Class 6 felony shall be punished by the imposition of a definite sentence, which is within the presumptive ranges. And I think if you excise that, the language that we have in the presumptive, or in the aggravated circumstance provisions could be read as guiding the trial court's discretion within the overall range. This court disagrees and thinks that you'd have to excise more language than that. We'd ask this court to do that. And even if a clean excision is not possible, we'd still ask you to do this because it's the system that best effectuates the General Assembly's intent, like it did recently in Tate with the juvenile life sentence case, where it couldn't just excise language because it applied to both juveniles and adults, but they still created this, or imposed the system as a remedy that best effectuated the General's intent, what they thought the General Assembly would have intended if its system was unconstitutional. And just as a slight point there, the defendant asks or suggests that it might be inappropriate to apply to him under La Rosa because under due process ex post facto principles. And the test there is, I know you talked about this earlier today, but unexpected and indefensible. And because this is doing exactly what Booker did not too long ago, I don't think that it would be an unexpected and indefensible solution for this issue.
Mr. Swanson, can you address the remedy, hypothetically, if we were to disagree with you?
Sure.
What should the remedy be here? Do we send it back? Does it get a new hearing? Is it harmless? I mean, what's your position?
Well, I mean, I tried to anticipate all the possibilities in my answer brief, but it really depends on what you decide, and what you decide if it's unconstitutional and what that means and what the remedy is going to be for how that's unconstitutional. So
let me ask you more specific.
Yeah,
I understand your struggle. I do. If we said there was Blakely error here, would it be harmless, and why?
Okay. Well, again, that gets to what's the remedy for, or what is the system that exists now with the non-constitutional statute? And so if that's the basis for the Blakely problem, then if the remedy is what we're requesting here, that you would get rid of the presumptive ranges, then the remedy would potentially be resentencing without the restraint of the presumptive ranges. That was what they did in Booker. But because I think the court's sentence that wouldn't necessarily be the case, and because the trial court's findings here make it clear that it was not, the constraints of the presumptive system did not limit its decision to in the sentence it imposed in this case, because it imposed the maximum, that wouldn't even be necessary to have a remand. If there are other scenarios in particular you'd like me to discuss, I think I go through them all in the answer brief, but that would be a request there. As far as if this court wants to consider the Court of Appeals opinion regarding harmlessness, I'd note that they only addressed harmlessness in the context of the Lopez scheme. For the defendant's challenge to Lopez, they just rejected it on its merits. And so their analysis of harmlessness under the Lopez scheme, I don't think is really challenged, that they properly find those underlying facts that opened up the range were uncontested and established by overwhelming evidence. And the defendant's arguments are all premised on it having to find more than that. So if it didn't, I think that the Court of Appeals analysis could be affirmed on that basis, but I don't think this court has to address it, because if it just applies Miesenhalter, there was no error and there's no need to get to that issue. And then the last thing, unfortunately I don't have a lot of time, is the due process charging document issue. And so the one thing I did want to just emphasize there is that this court addressed that issue in People versus Lacey, and part of what its analysis was relying on the United States Supreme Court holding in Euler versus Bowles, and that was the case where the U.S. Supreme Court held that if you're having a substantive charge and a habitual charge, the defendant is not entitled under due process to advance notice before the substantive offense is charged that you're going to be charged with habitual crimes. Our statute does do that, but that's not required by due process, and that remains good law. And I think that's substantial support for the idea that these do not have to be charged in the charging document. So I see I'm out of time. Thank you. And
Good, you timed that well, right?
Decision be affirmed.
I'm subject to being corrected. I believe both counsel have used up all their time. So we appreciate the arguments of both counsel. The case will stand submitted, and we'll be in recess until 1:30.